I've been keeping an eye on these judges who claim Bruen's too confusing to apply, and honestly, it's a load of crap. The Supreme Court just slapped that excuse down hard, and whether they meant to or not, they just put the Second Amendment right back in the driver's seat. What's up, everyone? This is Ted from Line 45, and today, we're going to take a look at how a case that wasn't even about guns just gave anti-2-ampere judges a serious gut check, and why this could bring some much-needed backbone back to Bruen across the country. Before I start, I would really appreciate it if you would push those buttons below, the subscribe button, the notification bell, all of them. This is not necessary, but those little clicks help a brother out. Plus, it pushes me to give you more valuable gun-related content on your screen. Now, buckle up, and let's get back to the video. When I first saw Medina versus Planned Parenthood hit the docket, I didn't think twice. Medicaid funding? Not exactly a headline grabber for folks like us who care about the Second Amendment. But that's the problem. Too many people missed what really happened here. The case had nothing to do with guns on the surface, but under the hood, it showed us exactly how the Supreme Court thinks when judges start playing games with clear rules like Bruen. In Medina, a group of patients sued under Medicaid law, trying to block Texas from removing Planned Parenthood from the state's list of eligible providers. They leaned on the federal language that says patients can choose any willing and qualified provider. But the court, by a 6-3 margin, said no. That phrase didn't give people the right to sue. The court basically told the lower courts to quit reading between the lines and stick to the damn statute. Sound familiar? That ruling might not mention guns, but it's running on the same fuel as Bruen. Original meaning, strict text, no interpretive gymnastics. So when judges say they're confused about how to apply Bruen to magazine bans or carry permits, Medina is the court saying, tough luck, do your job, follow the text, respect the Constitution. And the more you watch how they worded that opinion, the more it feels like a warning shot to every anti-2-ampere judge who's been trying to stall since Bruen dropped. You start to see how all this ties back to Chevron, ATF overreach, and the court finally forcing some accountability. When Bruen dropped back in 2022, it was a game changer. For once, the Supreme Court gave us a clear-cut framework that put real teeth in the Second Amendment. No more interest balancing, no more public safety loopholes. If a modern gun law doesn't have a historical twin from the 1702nd or 1802nd, it's probably unconstitutional. Simple, right? You'd think so. But man, the lower courts have been trying everything they can to wiggle out of it. Instead of applying the ruling as written, a bunch of federal judges started pretending like it was too vague. They acted as if looking to the founding era for analogs was some impossible task. They didn't stall because they didn't understand it. They stalled because they did, and they didn't like where it led. Look at cases like Duncan versus Bonta in California, where a judge originally struck down the state's magazine ban under Bruen, only to have the Ninth Circuit push it back for a redo. Or Rahimi, where the Fifth Circuit said even someone under a domestic violence restraining order still has Second Amendment rights under Bruen, and the government scrambled to get it reversed. Lower courts are trying to carve their own version of Bruen, or just flat-out delay. They're buying time, hoping the politics shift. But with rulings like Medina, the Supreme Court is showing it hasn't forgotten how Bruen is supposed to work, and it's not about compromise. And now that the Chevron doctrine's gone, these judges won't be able to hide behind agency discretion either. Now, if you've been following these rulings closely, you know Loper Bright versus Raimondo was a big one. That case didn't mention firearms either, but it torched a legal doctrine that's been used for decades to justify all kinds of government overreach, including the kind we've seen from the ATF. We're talking about Chevron deference, the rule that said courts should defer to federal agencies, like the ATF, when the law's wording was a little vague. Well, that's over now. The court threw it out. They ruled that judges can't just hand their responsibility off to federal agencies anymore. If the law isn't clear, it's the judge's job to figure it out, not the ATF's. That matters a whole hell of a lot when you think about how the ATF keeps reclassifying things like bump stocks, pistol braces, and forced reset triggers out of thin air. Pair that with Medina, where the court said judges also can't stretch statutes just because they want a certain policy outcome, and you've got a full-on return to strict reading of the law. Judges are on the hook now. They don't get to pretend the ATF knows best, and they don't get to rewrite laws in court. So when a judge says they're not sure how to apply Bruen, or they're confused about the historical standard, tough. They don't get to hide behind the ATF or defer to agency guesswork. Not anymore. This puts the pressure right back where it belongs, and that's on the bench. And that's exactly what's needed to stop the slow roll attacks on the Second Amendment. You can read between the lines in Medina, and if you've been watching how Bruen has played out since 2022, the pattern's obvious. SCOTUS is done playing nice. They've seen the stall tactics. They've seen lower courts act like they're clueless about how to apply historical standards. And this wasn't some gentle nudge. The majority in Medina laid it out. The role of the courts isn't to stretch the law or invent new powers. It's to apply the text as written. Period. Same goes for Bruen. When a judge says they don't know how to compare a magazine ban to 18th century arms laws, that's not a legit complaint. It's a stall job. And the Supreme Court is now signaling that every time a lower court cries confusion, it gives SCOTUS the excuse to jump back in and reinforce the rules. That's what happened in Duncan v. Bonta. California's magazine ban got struck down under Bruen. But instead of accepting the ruling, the Ninth Circuit tossed it back to the same judge for a re-review, dragging the process out and hoping to water it down. SCOTUS sees this pattern, and Medina proves they're not going to let it slide forever. They're not rewriting anything. They're reminding judges that the Constitution already says what it means. The minute courts start playing dumb, they're inviting the Supreme Court to get involved and make things even clearer. And if that keeps happening, anti-gun laws are going to start falling faster and harder. You don't have to be caught in a lawsuit to feel what's going on here. If you carry daily, own standard capacity mags, build your own rifles, or live in a state that tries to micromanage everything from barrel length to what's pinned in your stock, you're already part of this fight. And what happened in Medina, paired with Loper Bright, just tipped the scales back our way. Thing is, Bruen didn't just shake up one law. It set a new standard that was supposed to hit everything from carry permits to assault weapon bans. Problem is, courts have been dragging their boots, slow-walking decisions, and hoping someone else would step in to undo the whole thing. Some of these judges are straight up ignoring the rule. Others act like historical analogs are impossible, just to stall the inevitable. What Medina does, even without being a gun case, is put pressure right back where it belongs. It says the quiet part out loud. We're done babysitting judges who refuse to follow the Constitution. So whether you're watching the Illinois rifle ban, the California mag ban, or whatever the ATF cooks up next, the writing's on the wall. The Supreme Court is tightening things up, and they're not going to let lower courts wander off the reservation much longer. This affects everyone who owns a gun, not just folks wrapped up in lawsuits. Because if SCOTUS keeps stepping in like this, the days of judges picking and choosing what part of the Second Amendment they'll respect might finally be numbered. If you're a 2-ampere attorney, or hell, even a regular gun owner fighting a charge, you just got a brand new card to play, and it's a damn good one. Medina is the kind of ruling lawyers can drag into court when a judge starts dancing around Bruen. It gives them more than just the Second Amendment to stand on. It gives them backup straight from the Supreme Court on how courts are supposed to handle the law. By the book, no sidestepping, no policy nonsense. Judges love to act like Bruen didn't give them enough detail. They'll say things like, well, how far back do we go in history? Or, there's no perfect historical match for modern weapons. And now, pro 2-ampere attorneys can just hold up Medina and say, cool story, Your Honor. But the Supreme Court already told you. Stick to the damn text. Quit inventing loopholes. This ruling's especially useful in appellate work. If you've got a case on a mag ban, rifle restriction, or carry permit law that a lower court upheld using twisted logic or policy excuses, Medina helps slam the door shut on that garbage. It turns up the pressure on judges to quit whining about unclear standards and do their damn jobs. And the best part? This isn't just about guns. It's part of a bigger shift, where courts don't get to hide behind alphabet agencies or fuzzy legal theories anymore. This is about clarity, and that clarity puts the Second Amendment back on solid ground. You don't need to be in court to feel the weight of rulings like Medina. This stuff trickles down fast. It's about whether you can keep your carry license, whether your mags are legal next year, and whether your state can ban rifles you've owned for a decade. And what just happened with the Supreme Court? It's the kind of shift that tells me the tide might finally be turning back in our favor, if we stay on top of it. Here's what to keep an eye on. Watch how circuit courts respond to Bruen going forward. Now that SCOTUS has made it clear they're not in the mood for confused judges or bureaucratic middlemen, those lower court rulings can't play fast and loose anymore. If you see a judge start ignoring the historical test or leaning on public interest arguments again, they're not just getting sloppy, they're asking to get slapped down. Also, watch for how this affects ATF enforcement. With Chevron gone and Medina laying down a no BS reading of federal law, the ATF won't be able to reclassify things on a whim like they used to. That might not stop them from trying, but it gives our side a stronger footing to fight back. Bottom line is, Medina may not be a gun case, but it's damn important to every gun owner out there. Because now we know the court's watching. And if these judges keep dragging their feet, South Carolina Otis is more than ready to hit the gas.